Kinda.
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Right away, this is not a routine plea hearing. This is a pressure moment. The judge is doing something extremely important at the start, confirming voluntariness. When a defendant pleads guilty, the court must ensure the plea is knowing, intelligent, and voluntary. That means no threats, no coercion, no hidden deals. And when Mr. Hampton says, kind of, everything changes. That one phrase can unravel an entire plea agreement. Because if a plea is entered under coercion, it becomes constitutionally defective. Now here's the bigger issue. He suggests the judge herself pressured him by referencing jail time. That's explosive. Judges can explain consequences, but they cannot threaten outcomes to force a plea. Watch closely how the judge handles this, because one wrong move here could collapse not just one case, but two linked cases headed to mental health court. This is where courtroom psychology, procedure, and strategy all collide. Ask yourself, was this fear or was this misunderstanding?
Hmm. Well, technically, Your Honor.
And would like to enter that into the record.
The people of the company.
Thank you.
We did not write that the agreement. He has been admitted to the 15th District Court Mental Health Court.
Got it.
Today, at his preliminary exam in 24 at 55262, he'll be entering a plea on Tuesday to attempt RNO in that case.
Let's pause and unpack something critical here, mental health court. This isn't just a regular plea deal. Mental health court is a specialized diversion program designed to provide treatment and structured supervision instead of traditional incarceration. That's significant. It means the court system recognizes underlying mental health factors and is offering an alternative pathway. But entry into these programs often requires strict compliance and plea agreements. Timing matters, jurisdiction matters, and paperwork matters. That's why the judge is cautious about merging cases without proper files present. Courtrooms are procedural machines. Even if everyone agrees, the process must be followed correctly. Do you think procedural caution slows justice down or protects it? Because here, one missing file could derail a carefully negotiated outcome.
Got it.
Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I do believe that the building that you faster.
Oh, sorry.
But I don't believe it's.
What? Okay.
Talking about violence.
All right, we'll just address this case today.
He's going to enter a plea in another case
Uh,
that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of two cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond.
Now the judge explains something many viewers don't realize. Different judges because of different jurisdictions. Even though the cases are connected by the same defendant, they occurred in separate municipalities. That means separate courts initially handle them. But here's the key reassurance. Both cases are expected to end up in mental health court supervision. The judge is actually calming the defendant's anxiety by explaining the pipeline. That's judicial transparency. Notice how Hampton keeps asking questions. That's not defiance, that's confusion. And confusion during a plea is dangerous because a plea must be entered with full understanding. If he doesn't understand, the plea cannot stand. Would you feel comfortable pleading guilty if you weren't sure which judge controlled your future?
And request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah,
Right now, I'm trying to get these pleas done.
thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes,
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing, would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right, Your Honor.
May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
And man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Balbo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we're just talking about with Judge Balbo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or yes, in Ypsi City, it looks like. I'm sorry, Ann Arbor Township. Okay, so they occurred in 2 separate jurisdictions.
Okay.
Okay, that's why you have 2 separate judges. But what's going to happen, I think this is probably really the crux of your question.
Here it is, the moment that shakes the entire hearing. Kind of. That single phrase triggers alarm bells. The judge must immediately stop and clarify. When Hampton says the judge pressured him with jail time, this becomes extremely delicate. Judges are allowed to explain sentencing ranges. They are not allowed to threaten punishment to force compliance. Notice how the judge doesn't explode. Instead, she pauses proceedings and gives defense counsel a chance to speak privately with him. That's procedural fairness in action. She even says she might blow all of this up if she's not comfortable, meaning she would reject the plea entirely. That protects the record. This is what judicial integrity looks like under pressure. Question for you. Was Hampton genuinely confused, or was this hesitation revealing deeper doubt?
You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part.
We're back on the record, and the judge repeats the voluntariness questions. This is strategic and protective. Once coercion is alleged, even casually, the judge must rebuild the record cleanly. Now Hampton answers clearly. No threats, no coercion, voluntary. That reset is essential. But here's something interesting. Sometimes defendants associate the reality of consequences with pressure. Hearing, "You could go to jail," feels threatening, even when it's legally accurate. The line between explanation and intimidation can feel blurry emotionally, but legally, it's distinct. This is why judges speak carefully. Do you think defendants always fully grasp the difference between legal reality and coercion?
The sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to valuable as well.
It will get there. It just can't go directly that way.
Okay,
Okay.
for sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
Yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah,
Okay. So to the charge of aggravated assault, how do you plead?
guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah,
All right. You signed an advice of rights form, correct?
yeah.
And now
You
the
have any-
factual basis falls apart. During a guilty plea, the defendant must admit facts that support the charge. But Hampton describes being attacked first, pushed, hit, thrown, property broken, and biting only in self-defense. That narrative doesn't cleanly establish aggravated assault. The judge immediately sees the problem. If the facts don't support guilt, she cannot accept the plea. This is where many viewers misunderstand plea hearings. It's not enough to say, "I'm guilty." The court must establish a legal basis. That's why she suggests possibly switching to a no-contest plea, which allows conviction without admitting the detailed facts. This is procedural chess. Was Hampton trying to protect himself or unintentionally undermining the agreement?
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Oh,
Well, technically, you, Your Honor.
oh.
Mr. Hampton, so
Tell you what. Why don't we?
Let's break this down professionally. 2 misdemeanor cases, aggravated assault and attempted resisting and obstructing, tied to a pathway into mental health court. The goal was resolution and structured treatment supervision. But the plea nearly unraveled due to perceived coercion and a factual narrative that conflicted with the charge. The judge acted cautiously and correctly, halting proceedings when voluntariness was questioned, clarifying the record, and refusing to accept a plea unsupported by facts. That protects both the defendant's rights and the integrity of the court. Ultimately, the matter was adjourned for further consultation, a strategic reset rather than a collapse. This case shows how fragile plea agreements can be. One unclear statement can change everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.